Can I acknowledge some past parliamentary colleagues, shall I call them parliamentary elders and friends, and also colleagues from the bar. It's an honour, and I very much appreciate all of you making time to hear from me today. This paper is one I want to acknowledge was prepared with the assistance of Jai Beardo, who's a research assistant of mine, a very smart fellow, and I thank him very much for being a great partner on the project. Onwards. At the 1858 Republican State Convention in Springfield, Illinois, Abraham Lincoln famously declared that a house divided against itself cannot stand. Lincoln's words, however, were not his own. The concept of a house divided is as old as the Bible itself and can even be found in Thomas Hobbes's seminal work, Leviathan. While Australia's federation was not born out of war or revolution, our founding fathers were well aware of this ancient principle, agreeing to unite the states in one indissoluble federal commonwealth. Indeed, at the 1891 convention, Henry Parkes proclaimed, Australia, as Australia, shall be free, free on the borders, free everywhere, in its trade and intercourse between its own people, that there should be no impediment of any kind, that there should be no barrier of any kind between one section of the Australian people and another, but that the trade and the general communication of these people shall flow from one end of the continent to the other. To my mind, it would be futile to talk of union if we keep these causes of disunion. Enacting Parkes's vision of a free, prosperous and united Commonwealth, the founders included in the Constitution Section 92, one of Australia's few express constitutional freedoms. Section 92 emphatically and imperatively declares that trade, commerce and intercourse among the states shall be absolutely free. Its inclusion in the Constitution was undoubtedly central to the Australian federal project. However, since Federation, Section 92 has proven to be, well, a divisive provision, subject to over 140 High Court cases, far more than any other single provision in the Constitution. While it was less litigated after the High Court's landmark decision in Cole and Whitfield, Section 92 has returned to the spotlight because Australia is currently a house divided by the closure of some of our states' borders. Last year, during the height of the pandemic, Clive Palmer unsuccessfully challenged the constitutional validity of Western Australia's hard border under Section 92. However, the recent refusal by some state premiers to commit to reopening their borders when the nation hits an 80% double-dose vaccination level has raised fresh concerns about the interpretation of Section 92. Accordingly, it's my intention tonight to assess the current state of jurisprudence under Section 92 of the Constitution, including the court's decision in Palmer. I'll go into three important doctrinal developments that come out of it. First, the reintegration of Section 92's intercourse or interstate movement limb. Second, the entrenchment of the Wotton approach for assessing constitutional validity. And third, the expansion of proportionality testing in Australian judicial review. Ultimately, it's my view that Section 92 is now at its most fragile point since Cole and Whitfield, with the court potentially divided both on its scope and the relevant standard of scrutiny it requires. With border restrictions continuing to persist in lieu of high vaccination rates in some places, the High Court's renovation of Section 92 might not yet be complete. Indeed, it may well be tested again by another non-government party before the pandemic is out. But before turning to a full consideration of the High Court's decision in Palmer, it's important to put Section 92 in context. We know that that provision requires that trade, commerce and intercourse among the states shall be absolutely free. While the words absolutely free appear relatively straightforward and definitive on their face, the phrase has long given rise to a range of intensely competing interpretations by the High Court. The principal issue arises from the difficulty in giving the words absolutely free a literal meaning in light of conflicting legislative powers over trade and commerce and quarantine. For instance, these two heads of legislative power allow for regulation over similar subject matter that Section 92 says should be absolutely free, and in a sense While the legislative powers expand the ability to make restrictions, Section 92 confines them. So it means that those words, absolutely free, have been the ones that occasion the most problems in relation to Section 92, and arguably that's still the case now in the COVID environment. And so it begs the question, when we get to the guts of it, what do the words absolutely free really mean? From Federation, the High Court has grappled with whether the words absolutely free are to take their colour and meaning from the philosophy of individualism and liberalism, or whether they should be taken from the economic theory of free trade. Early on, this distinction was neatly embodied in the imposing views of Justice Evatt, who strongly supported a free trade kind of interpretation of Section 92, and Justice Dixon, who, on the other hand, approved an individual right kind of approach. According to Leslie Zines, by the late 1930s, the High Court's reasoning more closely resembled the approach put forward by Justice Evatt than it did that of Justice Dixon. But in 1948, the High Court affirmed the individual rights approach to Section 92 in the bank nationalisation case. In an act of what now seems quite some irony, it was Doc Evatt, then Attorney General in the Chifley government, who argued the case for the Commonwealth against those who would become future High Court justices in Garfield Barwick and Frank Kitto. Broadly speaking, Section 92, under that individual rights approach, was to guarantee individuals a right to engage in trade, commerce, and intercourse across state borders, free from legal restriction, unless such legal restriction could be regarded as reasonable regulation of that freedom. In other words, any governmental restriction on interstate trade and commerce would be constitutionally suspect, regardless of whether it was discriminatory or not. But there continued to be dissenting voices on the free trade side. When he retired in 1952, Sir John Latham appeared to hold his preference to the free trade approach still very closely, professing that, quote, when he died, Section 92 would be found written on his heart. Nevertheless, while Section 92's interpretation had waxed and waned over the course of the 20th century, by the 1980s, the individual rights view had found favour with a majority of the court. However, the individual rights approach was also eventually put to the sword, with the free trade view returning to ascendancy in the landmark case of Colin Whitfield, which has aptly been described as the Section 92 revolution. In Colin Whitfield, the court unanimously declared that Section 92 requires that interstate trade and commerce be free of discriminatory burdens of a protectionist kind. The focus of the provision, their honours held, was on preventing protectionism rather than promoting personal freedom. Wildly different conceptions, I might suggest. Former Chief Justice Barwick later described the reasoning in Colin Whitfield as, quote, really laughable, and in a further quote, terrible tosh. At this Society's launching address in 1992, another former Chief Justice, Sir Harry Gibbs, rightly posed the question, quote, who in 1901 could have predicted the course of interpretation of Section 92? As such, the overall effect of Colin Whitfield was to largely render Section 92 one that was relevant to free trade and protectionism. Nevertheless, for those supportive of the individual rights view, there remained some hope, with the court leaving the content of the distinct intercourse limb to be decided for another day. In this context, intercourse refers to the physical movement and communication of people and goods across state borders. While this limb was not impugned in Colin Whitfield, there were clear hints in the court's reasoning that restrictions on interstate intercourse would be harder to justify than those on trade and commerce. For example, the court referred to interstate movement as a guarantee of personal freedom to pass to and fro among the states without burden, hindrance or restriction in a way that suggested it was a fait accompli. One final development emerging post-Colin Whitfield was the relevant level of judicial scrutiny applied to the trade and commerce limb. In Castlemaine Tooheys in South Australia, the court accepted that legislative burdens on Section 92 could be justified if they were reasonably appropriate and adapted to a legitimate public policy purpose. In Betfair in West Australia, the court further refined the standard into one of reasonable necessity. That is, are the measures reasonably necessary for the enactment of some constitutionally legitimate public policy purpose? This standard of review is reflective of a loose form of proportionality analysis, which is found elsewhere in Australian constitutional law. And so the position of Section 92, pre-Palmer, could be summarised in this way. 1, interstate trade and commerce is to be free of discriminatory burdens of a protectionist kind, reflecting the free trade view of the provision. 2, that burdens on interstate trade and commerce can be justified if they conform to the standard of reasonable necessity. It's a fairly high level of judicial scrutiny, but it involves proportionality considerations. And 3, intercourse or interstate movement is a separate and distinct limb to trade and commerce, bearing some resemblance to a personal freedom or an individual right. So, in short, the words absolutely free don't mean what the man or woman on the street might expect for them to. So let's turn then to Palmer. Last year, after being rejected a border pass exemption, Clive Palmer challenged the constitutional validity of Western Australia's hard border closure, arguing that it infringed the freedom of interstate movement that's provided for in Section 92. Importantly, before the case was fully heard in the High Court, part of the proceeding was remitted to the Federal Court for fact-finding. The significance of this part of the process should not be underestimated. Justice Rangier of the Federal Court here in Brisbane was tasked with assessing the reasonable need and efficacy of the border closure. Essentially, he was asked to undertake an analysis of its proportionality. Notably, though, Justice Rangier was confined to an analysis of health risks only, and he was therefore unable to consider any economic or social risks that were posed by state border closures. His Honour concluded that alternative measures such as mandatory testing, a period of quarantine, or the imposition of a targeted hotspot regime would be less effective than border restrictions in preventing the importation of COVID-19, particularly given that a vaccine was not yet available at that time. Reading that conclusion, I can't help but be reminded of Justice Dean's famous piece of obiter from the Tasmanian Dams case, where His Honour quipped that a law requiring all sheep to be slaughtered would, of course, be an effective means of combating the spread of some obscure sheep disease. Significantly, though, Justice Rangier held that a precautionary approach towards the border measures should be adopted. Consequently, Mr Palmer's challenge was unanimously rejected by a 5-member bench of the High Court, with Chief Justice Kiefel and Justice Keane writing together and Justices Gageler, Gordon and Edelman writing separately. Their Honours all found that Western Australia's hard border closure did not infringe Section 92 of the Constitution. And as I mentioned at the beginning, there are 3 areas of doctrinal significance that come out of that reasoning that impact upon constitutional law in general and Section 92 in particular. First, the High Court unanimously discarded the distinction that was drawn in Colin Whitfield between trade and commerce and intercourse, reintegrating these 2 limbs of Section 92. Accepting submissions that were made by the Attorney-General of Queensland, the court held that the distinction drawn in Colin Whitfield is not consistent with a modern approach to constitutional interpretation, as there is, quote, no textual basis for separating the components of Section 92. The court there emphasised that the phrase trade, commerce and intercourse is, to use their words, a composite expression, and to subject the words of composite expression to different tests would result in what they described as constitutional incoherence. While there is some force in arguments for consistency, there can be no denying that the reunification of those two limbs has ultimately weakened Australians' rights of free movement, bringing to an end the individual rights approach. Rather than providing a personal freedom of interstate movement, intercourse is now subject to the same level of scrutiny as trade and commerce. Therefore, despite Parkes's grand vision for free movement throughout the Federation, Section 92 now, in practicality, provides a very limited form of protection. So where does this leave the rights of free movement that Australians have in this country? Well, last year, in Gurner and Victoria, the High Court unanimously determined that the Constitution does not contain an implied freedom of movement. Their Honours held that such a right is not sustained by the text or structure of the Constitution, nor Australia's system of representative and responsible government, and nor as an incident of Section 92. Likewise, in Cotterill and Romanas, the Supreme Court of Victoria determined that Victoria's lockdown restrictions did not breach the implied freedom of political communication. Earlier this year, in Newman and the Minister for Health and Aged Care, Justice Thorley of the Federal Court declared that Australian citizens possess a fundamental common law right to re-enter Australia, a finding that was not disputed by the Commonwealth, it's worth noting. However, fundamental common law rights are subject to the principle of legality and may be abrogated by legislation if there are clear words expressing an intention to do so. And in this case, Justice Thorley held the Biosecurity Act effectively abrogated the common law right of citizens to re-entry. As such, Australians have that limitation on their individual rights to re-enter. While some from the Academy have argued that the High Court should imply this right of re-entry into the Constitution, I'd suggest that Mr. Beardo and I respectfully disagree. It's one thing to declare that Australians should have a right to re-enter their country of citizenship, a proposition with which I agree, I might add. It is another thing entirely, though, to imply that right into the Constitution, even if such a right is desirable in a free society. The proper mechanism for constitutional alteration is through the referendum process provided for in Section 128 of the Constitution, and in the absence of doing so, by democratically elected legislatures making laws respectful of their citizens' fundamental rights. It shouldn't be affected, in contrast, by undemocratic judicial activism. To imply rights into the Constitution in the absence of clear textual or structural hooks is, as Justice Dawson has said, to slide into uncontrolled judicial lawmaking. It's highly concerning to me that the High Court has been so willing to read down Section 92, one of the Constitution's very few express rights, while at the same time being willing to give an expansive operation to implied rights, which can scarcely be found in the text of the Constitution. It's a contradictory approach to constitutional interpretation to adopt an expansive view of implied rights while at the same time adopting a narrow view of express rights. If one were approaching the task of determining jurisprudence afresh, one would suggest that to flip those approaches would be much more appropriate. But in any event, Palmer is now the leading case on the freedom of intercourse that is protected by Section 92. And we suggest as a result that Section 92 now unfortunately provides Australians with weaker rights of movement throughout the Federation. The second important development to doctrine that comes out of Palmer stems from the court's application of the Wooten approach for assessing constitutional validity. In Wooten and Queensland, a majority of the court determined that questions of constitutional validity are to be directed towards empowering statutory provisions rather than any executive directions made under a statute. For example, if statutory provisions are found to be constitutionally permissible, then the validity of any instruments made under those provisions is a matter for administrative law rather than constitutional law. Now, applying that idea to this approach from Palmer, their honours all found that sections 56 and 67 of Western Australia's Emergency Management Act did not infringe section 92 of the Constitution. And as a result, they held that Mr. Palmer was wrong to directly challenge the quarantine, closing the border directions. As David Hume has argued, the Wotton approach works powerfully in favour of the validity of statutes, as the court doesn't assess the validity of an exercise of power by looking at its effect on a particular individual, for example, in assessing whether there has been an infringement of the implied freedom of political communication. One doesn't ask how the law has affected that particular plaintiff. And it's a point he makes well. This line of authority, though, undoubtedly weakens the validity, or should I say the vitality, of Australia's relatively few constitutional freedoms by depriving plaintiffs of the type of fact-sensitive analysis that may be required to reach the view of invalidity. Consequently, the effect of Palmer is to further entrench the Wotton approach towards constitutional validity, which without doubt increases the difficulty of winning any future hypothetical challenges under section 92. Third, by a slim majority of 3-2, the decision in Palmer endorsed the approach of structured proportionality for the new level of judicial scrutiny for burdens on section 92, displacing the reasonable necessity standard that was in place prior. Justices Gageler and Gordon dissented on this point, maintaining their strong opposition to the use of the concept of structured proportionality. Instead, their honours respectively preferred tests of reasonable necessity and reasonable regulation, which are ostensibly lower levels of judicial scrutiny. Structured proportionality involves asking whether a law satisfies the following three questions in this sequence. First, is the law suitable as having a rational connection to its legitimate purpose? Second, is the law necessary in the sense that there are no obvious and compelling alternative, reasonably practicable means of achieving the same purpose that have a less restrictive effect? And third, is the law adequate in its balance? This is a criterion requiring a value judgment consistently with the limits of the judicial function, describing the balance between the importance of the purpose served by the restrictive measure and the extent of the restriction it imposes. I'd suggest that that third is where the biggest judicial activism risk arises. But an answer to no for any of those three parts will result in invalidity. Structured proportionality has been argued, or arguably been, the most important doctrinal tool in constitutional rights law around the world for decades, despite only being received into Australian jurisprudence quite recently. It currently has two accepted uses in Australian judicial review, both of which arise in the constitutional law context. First, it's the standard of scrutiny for legislative or executive acts, which purportedly burden the implied freedom of political communication. And second, it's now used to test burdens on interstate trade, commerce and intercourse under section 92. Its reception into Australian constitutional law has been met with fierce resistance from some members of the judiciary and academy. While we accept that structured proportionality has some role to play in constitutional law due to its ability to make judicial reasoning more transparent and predictable, there are two aspects of this approach that I would suggest are fairly troubling. First, structured proportionality takes judges awfully close to the role of a legislator. Speaking directly to this important distinction, US Supreme Court Justice Neil Gorsuch has stated, legislators may appeal to their own moral convictions and to claims about social utility to reshape the law as they think it should be in the future. But judges should do none of these things in a democratic society. Judges should instead strive to apply the law as it is, focusing backward, not forward, and looking to text, structure and history, not their own moral convictions or the policy consequences they believe might serve society best. Structured proportionality, therefore, sits very uncomfortably with this distinction, often inviting judges to step directly into the shoes of a legislator by allowing them to pick and choose policy prescriptions. In Momsilovic and the Queen, Justice Hayden echoed this sentiment, stating that proportionality inquiries are not tasks for judges, they are tasks for a legislature. In particular, these concerns are elevated by structured proportionality's final criterion of adequacy in the balance, which inevitably involves polycentric decision-making. Indeed, Justice Edelman, a proponent of structured proportionality, has indicated he is reluctant to invalidate a law at this final stage, highlighting that it has been effectively abandoned in some jurisdictions. In the decision in Liberty Works and the Commonwealth, Justice Stewart also suggested that this limb should be approached with very considerable trepidation. As such, unless structured proportionality is kept strictly in check, there is, as has been said by justices from time to time, a substantial risk that courts will transgress their legitimate function. Second, the ongoing use of structured proportionality by the High Court in constitutional cases raises the prospect of its eventual migration into administrative law, where it would clearly be an inappropriate standard of review in light of the important distinction between merits and legality. Unfortunately, notions of proportionality have already begun to seep across into administrative law, principally through the reasonableness ground. One recent high-profile example of this is the decision of Justice Raries in the Federal Court in the Brett Cattle Company Proprietary Limited and the Minister for Agriculture. In that case, Justice Raries used structured proportionality to determine that the Gillard government's 6-month ban on live cattle exports was unlawful on the grounds of unreasonableness. In doing so, His Honour held that the minister should have introduced a closed-loop supply chain rather than a total moratorium. This novel use of structured proportionality outside the constitutional context undeniably amounts to a new and radical approach towards legal unreasonableness, going much further than the more general notions of proportionality that were introduced in the Minister for Immigration and Leave. Now, I say this with a heavy heart. I'm a fervent supporter of our live cattle industry and very much wanted to see justice for those people who suffered so badly at the hands of what was a terrible policy decision. But this sort of judicial activism reminds me of a famous statement made by the late US Supreme Court Justice Antonin Scalia. He says, quote, "If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong." As I say, I'm happy for the outcome for those in the industry, but I am concerned by the risk presented by that precedent. As such, there is an active risk that the continued expansion of structured proportionality by the High Court will invite judicial activism by lower court judges, providing a licence to engage in merits review of administrative decisions and delegated lawmaking powers. Chief Justice French and Justice Bell were right to warn, in my view, or in our view, that structured proportionality must not come to reflect the birth of some exotic jurisprudential pest destructive of the delicate ecology of Australian public law. Nonetheless, returning to Palmer and Western Australia, every justice of the court found that Western Australia's hard border closure was a proportionate response to the pandemic. This determination was no doubt assisted by the factual findings of Justice Rangier, who on remittal found that the border closure was reasonably necessary and the most effective measure available at the time to combat the spread of COVID-19. His Honour's precautionary principle was mentioned with apparent approval in the joint judgment and was not the subject of criticism from any other justice. But it's worth noting, I think this is important, the decision in Palmer came long before the availability of a vaccine. As Chief Justice Kiefel and Justice Keane noted at the time, there is no known vaccine and no other treatment presently available to mitigate the risks of severe medical outcomes or mortality for a person who contracts COVID-19. This is no longer the case. Not only are vaccines now available, but more than 1.8 million Australians are being vaccinated every week. As more Australians become vaccinated, state border closures become less proportionate, a point that's been made by a number of prominent constitutional scholars, including Greg Craven, Anne Toomey and George Williams, all sides of what one might call the political fence. Yet Premiers Mark McGowan and Anastasia Palaszczuk have both threatened to keep their borders closed after 80% of their citizens are vaccinated. In other words, we are now faced with the absurd prospect that some Australians will soon be able to travel to Sydney and London before they can go to Townsville and Cairns. The cruelty of these closures is plain, particularly in light of the scant epidemiological evidence of their long-term effectiveness. In my home state of Queensland, we've seen diggers from Afghanistan refused entry to their home state, interstate Queenslanders told to go to homeless shelters when they run out of money paying for motels while they wait long periods for their application to be assessed by the bureaucracy, 3-year-old children kept away from their parents, relatives unable to be with each other in a loved one's final moments, families unable to mourn together at funerals, and the tourism sector brought to its absolute knees. Despite not being under lockdown, Queensland has the second highest unemployment rate in the country. And now the Queensland government is attempting to use a state border closure to shake down the federal government for more funding. Now, that's despite funding being at record levels, using federation politics as a cover for Labor's entrenched mismanagement and incompetence is, I would suggest, beyond the pale. In a health system where the number of administrators approximately equals the number of frontline nurses, we would suggest it is not money that is the problem. In any event, though, the Commonwealth picks up 50% of the bill on all COVID-related matters. As of the 8th of October, there are 8,000 Queenslanders trapped interstate with no indication of when they'll be allowed to return home. My office has been inundated with their pleas for help. But while Premier Palaszczuk has been rolling out the red carpet for NRL players and for their families, requests from regular Queenslanders have sadly fallen on deaf ears. Even Queensland's Human Rights Commissioner has criticised the Palaszczuk government, calling for a more consistent and transparent approach to border exemptions, indicating that some requests have favoured those who have a high media profile. This kind of disproportionate response is unfortunately nothing new in Australian history. For example, during the Spanish flu pandemic of 1919, the attempt to give the Commonwealth control over interstate movement of people quickly collapsed, with states closing their borders to protect their residents from the spread of disease. Western Australia even impounded the transcontinental train. It seems like not too much has changed over time in the West. So, in conclusion, where does this all leave us? Well, for Section 92, the Palmer case has reformulated our understanding in these terms. 1, interstate trade, commerce and intercourse are reunited into a single limb, officially spelling the end of the individual rights approach. 2nd, where restrictions on interstate trade, commerce or intercourse arise via directions issued pursuant to statute, Section 92 is only applied to the empowering statutory provisions. The executive directions are otherwise seemingly left to administrative law review. And 3rd, the relevant standard of judicial scrutiny applied is that of structured proportionality, though it should be said only by the slim majority of 3-2. The views of newly appointed Justices Stewart and Gleeson, then, will no doubt be decisive in determining which standard of review eventually prevails. A question mark also remains about the ongoing relevance of the concept of protectionism. In relation to its impact on public law more broadly, the following issues remain live. First, whether structured proportionality is an appropriate standard of review in Australian constitutional and administrative law. We would suggest it has a small role to play in constitutional law, but no place whatsoever in the administrative sphere. Second, whether the Wotton approach for assessing constitutional validity is correct or desirable when dealing with constitutional freedoms. And I'd suggest that the weight of evidence suggests it should not. And third, whether ongoing border restrictions fall foul of Section 92 or otherwise. In light of the role of structured proportionality, it is the fact-finding process that will inevitably be determinative of the matter. It's hard to imagine, though, with readily available vaccines and a high and rising vaccination rate when we look at the country as a whole, that finding of fact today would continue to support an assessment that border closures remain proportionate. I'd like to conclude by bringing us back to a short passage from the 1987 Constitutional Convention debate. There it was said, with most of these things, no one state is concerned with the management of the other, but there are certain matters, such as defence, quarantine, and various other things that we as a people say we are concerned not as residents of Victoria, Tasmania, or any other colony, but because our interests and desires are united. We say there is henceforth to be no distinction between us. Our interests and desires are united. Let us blot out of our future history and out of our future politics this arbitrary fact that we are residents of different colonies. I'd urge our premiers to adopt this spirit of a united and prosperous federation by committing to reopening our borders and, importantly, reuniting Australians. Thanks very much for your attendance and your attention.